Hi there, my name's Ron Wright. I teach here at the law school at Wake Forest University. We're going to be talking about a criminal procedure topic today. The topic is silence at trial. Defendants in the United States have the right just to remain silent throughout their criminal trial. They don't have to say anything. It's completely up to the government to prove its case. And if the defendant just sits there and says nothing, nobody can talk about that. Nobody can point out to the jury, hey, he's staying quiet. So comments on the right to silence, that's our topic today. Let's go in and talk. Okay, folks, let's get started. We're talking today about the right to silence at trial. Now, the Fifth Amendment to the U.S. Constitution says that everybody has a privilege against self-incrimination. And what this means is that we say to the government, you can't force somebody to come into a courtroom and answer our questions. Did you commit the crime? Admit it. You can't punish someone for refusing to answer. So we have a privilege, a legally protected privilege against self-incrimination. I don't have to help you prove the case against me. I can stay quiet. I can just sit here. The prosecution has to go first. The prosecution has to prove its case beyond a reasonable doubt. And as a defendant, I can just sit here and listen to you, and then at the end of your case, I can say, Your Honor, not enough. Please dismiss it. And if the judge thinks there might be enough, it can still go to the jury, and I can say to the jury, they didn't prove their case, and you don't have to hear anything from me. The defendant might bring in witnesses other than himself or herself. The defendant might bring in other witnesses to the events to explain why the defendant isn't guilty, and the defendant personally can just sit there and stay quiet and not say a thing, not take the stand, and that's just fine, we say. That should not be costly. So what happens when the judge or the prosecutor, or maybe both of them, try to make it costly at trial? Well, we've got a famous case on this question, Griffin versus California from 1965. Eddie Dean Griffin is charged with the murder of Essie Mae Griffin. He was seen with the victim during the day that she died. There's some evidence that places him in the same alley where her body was found, but we don't have an actual eyewitness, no recording or no eyewitness saying, yes, I saw him, kill her. But we do have this circumstantial evidence case. Griffin himself just stays quiet during the whole trial. And then at the end of the trial, the judge tells the jury, says, the defendant has the right not to testify. But, jury, you can treat his silence as evidence of guilt if he stays quiet about anything that, he could reasonably be expected to know about. If it's kind of weird to you, jury, that he's staying quiet about something, you can hold that against him. And says the prosecutor, during closing arguments, the prosecutor says, well, the defendant never rebutted a lot of our evidence. He never came up and said anything against us on this. He never had an answer for that. He never tried to rebut certain parts of our evidence. And then the prosecutor closes with this statement, Essie Mae is dead. She can't tell you her side of the story. The defendant won't. Again, a really obvious request to the jury to hold it against Eddie Dean Griffin for staying quiet during the trial. And so the Supreme Court, the U.S. Supreme Court says, that's a problem. You have made it costly for Griffin or for other defendants to invoke their right to silence at trial, and that makes this trial invalid. Judge, you can't say anything like that. You can't say that the jury's allowed to hold it against a defendant if the defendant stays quiet at trial. Prosecutors can't refer to the fact that the defendant is staying quiet at trial. You can't ask the jury to draw conclusions about that. So that's the basic holding, is that judges and prosecutors can't try to hold it against the defendant, can't try to convince the jurors to score points against the defendant for remaining silent. Why might a defendant remain silent at trial? Is it because they're really guilty and they don't want to look guilty on the stand? Well, sometimes that's true, I don't want to get up there and let the mean prosecutor cross-examine me and make me look like I'm really guilty. But sometimes it might just be, I'm not guilty, I didn't do it, but I'm a lousy witness. I'm really scared to death, I'm nervous, I'm going to come across looking nervous, and even though I'm not guilty, I'm going to look guilty. So some defendants might be worried about, looking guilty even though they're not. Some of them might feel like, well, I've got a prior criminal record. I've been convicted in the past of other crimes. If I get on the stand, the prosecutor will point that out to the jury. I didn't do this crime, but the jury might hold it against me that I committed crimes in the past. They might figure, aha, he committed crimes in the past. He must have done this one as well. I'm worried about the jury leaping to the wrong conclusion about my unfortunate past or my the past that I'm trying to get past. I'd rather just stay quiet. So we've got a mix of reasons why defendants might choose not to take the stand. And the Supreme Court decision here in Griffin versus California says, we just need to leave that to the defendant. They're going to have their reasons. And the text of the Constitution says privilege against self-incrimination. We're not going to make it costly. What do juries think about this? What's going on in a juror's mind when a defendant doesn't take the stand? It may very well be that a lot of jurors think, that's sort of a point against the defendant. I really would like to hear from that defendant about, what happened that day. What's her side of the story? So in the minds of jurors, it probably is a negative if the defendant's not taking the stand. But many defense lawyers might feel like, well, yeah, that's a negative, but it would be even more negative if they took the stand and they ended up looking guilty or revealing themselves to be guilty when they are guilty, or exposing to the jury the facts about their past prior convictions. So given that calculus, defendants might know, look, yeah, the jury's probably going to hold it against me to a small extent for not taking the stand, but I'm going to avoid even worse problems if I do take the stand. At least for some defendants, they see it that way. I want you to notice that this is something where you'll see a lot of variety around the world. If you go to some other countries, lots of other countries, there will be a legal obligation for the defendant to be a witness in the case. The defendant takes the stand and the judge can question the defendant about what happened and force the defendant to speak. Now, you might not punish them for perjury. You might understand that in that situation lots of people lie. But in a lot of legal systems around the world, there is no privilege against testifying. You don't have the right to say, no thanks, I'm not going to take the stand. Or in a lot of places, you have the right against taking the stand, but once you don't take the stand in a lot of systems, the jury or the other fact finder can draw negative inferences about that, can say, yeah, I'm going to hold it against you. It's something that makes me more likely to rule for the government, the fact that you didn't show up and tell me your side of the story. So lots of international variety on this question of the right to try or the right to silence at trial and the efforts by prosecutor or judge or other state actor to make it costly. So that's our topic for today.